Good morning and welcome to the CalFresh Eligibility Rules for Residents of Institutions webinar. Today we're going to provide an overview of the CalFresh policy rules regarding residents of institutions, including who and who isn't eligible for CalFresh. My name is Alexis Fernandez and I am the Chief of the CalFresh Policy Bureau here at the California Department of Social Services, CalFresh and Nutrition Branch, as well as your host for today's webinar. Before we begin, let's go over some logistics. Today's webinar will be in listen-only mode, which means you can connect your audio via your phone or computer, but all lines will be muted during the presentation. Which brings me to our next logistical detail. How do you ask questions? You can ask questions by using the question pane feature on the right-hand side of your screen. We have a lot to cover today and we will have limited time for questions at the end of the presentation. We'll do our best to answer as many questions as possible, but if we don't get to your questions during the live presentation, don't worry. We'll keep track of all questions submitted and we'll follow up as needed. This is the third webinar in the policy series related to the reversal of SSI cash out. After today, 2 webinars in the series remain. On March 5th, we'll discuss existing CalFresh rules for designating an authorized representative, and on March 19th, we'll review reasonable accommodations best practices. If you haven't yet registered for the remaining 2 webinars, you can do so on our webpage at cdss.ca.gov/CalFreshSSI. If you can't make it live, all webinars will be recorded and webinar materials will be posted, also on our web page, so check for updates regularly. Today's webinar will be recorded and the materials will be posted for everyone's review at the same website, so you can go there to find all the materials from the past, from today, and from the future. With that, let's get into our agenda for today. First, we'll all get on the same page. I'll provide some general information about the reversal of SSI cash out, just in case you're joining us for the first time today as part of this series. Then we'll go over the CalFresh eligibility rules for residents of institutions. With a common understanding of the residents of institutions rule, we'll dive into eligibility policy by type of institution, including drug addiction or alcoholic treatment and rehabilitation centers, group living arrangements, shelters for battered persons or domestic violence shelters, and shelters for homeless persons. We'll also discuss other meal service providers, such as communal dining facilities, where recipients can use their CalFresh benefits. Finally, we will highlight some resources for more information and answer questions as we can. We have a lot to cover, so let's get started. Those of you who've joined us for previous webinars in this series are familiar with the reversal of cash out. For those of you who are joining us for the first time, we'll do a quick review of the policy change and connect the dots to today's topic, CalFresh eligibility for residents of institutions. California implemented cash out in 1974 when the federal government began the combined federal and state Supplemental Security Income and State Supplementary Payment Program, also known as SSI-SSP. At that time, states were allowed to increase their SSP grant instead of administering what was then known as the food stamp program. California opted for this cash out policy and increased the monthly SSP grant by $10. Under cash out, SSI recipients are ineligible for CalFresh because, in theory, they are already receiving food benefits within their SSP grant. The challenge is that over time, the value of CalFresh benefits has increased with the rate of inflation, while the SSI cash out amount has remained flat and lost relative value. This means that many SSI recipients today live on a very limited budget intended to cover all basic needs and are likely to have unmet food needs, but are unable to apply for CalFresh. Last year's state budget reverses the policy known as cash out on June 1st, 2019. This means that beginning June 1st of this year, people receiving SSI can apply for CalFresh and, if eligible, receive food benefits in addition to their SSI and SSP benefit. This brings me to a very important point. There will be no change to the combined SSI-SSP benefit amount as a result of the reversal of SSI cash out. This is important, and we received a lot of questions on this topic, so I will repeat it again. There will be no change to the SSI SSP benefit amount as a result of this policy change. As of June 1st, 2019, all SSI SSP recipients will be determined eligible for CalFresh under existing eligibility rules for elderly and/or disabled individuals. For more information on eligibilities for households with an elderly or disabled member, check out the recording of our last webinar in this series. The recording and other materials have been posted to our CalFresh SSI webpage, as well as many other resources on the topic of expanding CalFresh eligibility as a result of the CalFresh reversal of SSI cash out. A large number of newly eligible SSI SSP recipients are expected to apply for CalFresh this summer. Some newly eligible SSI SSP recipients may be residents of institutions, which, depending on the specific type of institution and the person's living situation, may impact their eligibility for CalFresh. With the impending change, this is a great opportunity for a refresher on the CalFresh eligibility rules that apply for residents of institutions. And that's why we're gathered here today. So now we're going to go ahead and dive into the rules related to residents of institutions for the purposes of CalFresh. A resident of an institution is an individual who lives in an institution that provides the person a majority of their meals as part of that institution's normal services. A majority of meals is defined as 50% or more of 3 meals daily. Generally, residents of institutions are ineligible for CalFresh, unless they meet one of several exceptions. Before we get to those exceptions, let's review a couple of important details about who is ineligible for CalFresh. Again, an individual that lives in an institution that provides the person a majority of their meals as part of that institution's normal services is ineligible to CalFresh. To be a normal service of the institution, a meal plan does not have to be mandatory for all people that are residing there. An institution may offer an optional meal plan. Clients who opt into the meal plan that provides the majority of meals are considered residents of the institution. People who don't opt in are not considered residents of the institution. This distinction means that there may be people living at the same institution or facility, some who are considered quote-unquote residents of the institution for CalFresh purposes, while others are not because they are not receiving the majority of their meals from the institution. What does this mean? It means that the CalFresh definition of a resident of an institution and the corresponding eligibility rules are driven by whether a person receives a majority of meals from that institution. Generally, if a resident of an institution receives the majority of meals from the institution, they are by law ineligible for CalFresh. That said, there are always exceptions to the rule, and we're going to go over those exceptions next. The following individuals are not considered residents of an institution and can receive CalFresh benefits if they are otherwise eligible. Individuals who live in federally subsidized housing for the elderly, individuals who are narcotic addicts or alcoholics and reside at a treatment and rehabilitation center for the purpose of regular participation in that program, individuals who are disabled or blind and are residents of group living arrangements, individuals and their children who are temporarily residing in a shelter for battered persons or a domestic violence shelter, those terms are often used interchangeably, and individuals who are residents of a public or private nonprofit shelter for homeless persons. Lastly, residents of public institutions who apply for SSI prior to their release from the institution. An individual who resides at any of the previously mentioned facilities must be treated as a separate household from others with whom they live and may be eligible for CalFresh. For example, an individual who is temporarily residing at a homeless shelter or group living arrangement, etc., may apply for CalFresh, but must do so separate and apart for other individuals also residing at that shelter. To wrap up this slide, exceptions to institutional ineligibility apply. Individuals who meet any of the exceptions we just went over are not considered residents of an institution and may participate in CalFresh if they are otherwise eligible. Next, I'm going to provide some additional information on how these exceptions are defined for CalFresh purposes. These definitions should help identify whether or not an individual should be considered a resident of an institution. That will then inform their potential eligibility for CalFresh. In order to properly establish in order to properly apply the resident of institutions rules, you must be able to identify the institutions which qualify for an exception. Today, we're going to define in detail drug addiction and alcoholic treatment centers, group living arrangements, shelters for battered persons, and shelters for homeless persons. Let's start with the CalFresh definition of a drug addiction or alcoholic treatment and rehabilitation center, or a DAA center for short. And I am going to be using the term DAA center throughout the rest of the presentation, so just know that that refers to drug addiction or alcoholic treatment and rehabilitation centers. A DAA center provides drug addiction or alcoholic treatment and rehabilitation program. A DAA center may be operated by a private, nonprofit organization or institution, or a publicly operated community mental health center. The DAA center must be authorized by the United States Department of Agriculture, Food and Nutrition Service as a retailer, or it must be operating under Part B of Title 19 of the Public Health Service Act as a treatment and rehabilitation program. On the next slide, we're going to talk more about what it means to be operating under Title 19. For now, note that in California, the Department of Healthcare Services licenses treatment and rehabilitation programs, including those operating under the Public Health Services Act. To be considered operating under Title 19 of the Public Health Services Act, a treatment or rehabilitation program must be certified or licensed by the state Title 19 agency. As mentioned, in California, this is the Department of Healthcare Services. The program must either be receiving funding under the Act, must be eligible to receive funding under the Act, even if it's not receiving funding at the time, or must be operating to further the same purposes of the Act to provide treatment and rehabilitation of drug addicts or alcoholics. Title 19 requirements vary from state to state. Essentially, however, it requires that the program have a medical component to rehabilitation. Moving on to the CalFresh definition for a group living arrangement, or GLA for short. A GLA is defined as a public or private nonprofit residential home for disabled or blind individuals that serves no more than 16 residents. Note that for-profit facilities are not considered a GLA for CalFresh purposes. The GLA must be a nonprofit facility. Residents that live in for-profit group living arrangements are not eligible for CalFresh. Like DAA centers, the GLA must either be authorized by the Food and Nutrition Service as a retailer or must be operating under Section 16163 of the Social Security Act. In California, the Department of Social Services licenses group living arrangements for adults, including those operating under the Social Security Act. A shelter for battered persons, our next type of institution, and let me just say here that shelter for battered persons is the official term used in the CalFresh regulations. It's also known as a shelter for victims of domestic violence. Those two terms can be used interchangeably, but for this purpose, we're using the terminology used in the regulations. So a shelter for battered persons is a public or private nonprofit residential facility that serves battered women, men, and children. To qualify, the facility must have a portion of the facility set aside on a long-term basis to serve battered persons. The shelter must serve meals or provide food to the residents, and the shelter can either be authorized by FNS as a retailer or confirmed by the county as a facility that does indeed service battered individuals. A shelter for homeless persons is a public or private nonprofit facility that serves homeless persons. To qualify, the shelter must serve meals or provide food to residents. The shelter must also be authorized by FNS as a retailer or confirmed by the county as an establishment that does indeed serve meals to homeless persons. To wrap up this section, individuals that reside at a DAA center, GLA, shelter for battered persons, or shelter for homeless persons are exempt from the Residents of Institutions rule, which requires that certain individuals be determined ineligible for CalFresh. Later in this presentation, we'll provide guidance on each of those types of institutions. So just hold tight for more details. Throughout the previous section, I mentioned that FNS retailer authorization is required in some situations. So how can a county find out if a particular facility is authorized by FNS? A list of FNS authorized DAA centers, GLAs, and shelters can be found on the CalFresh resource page. This is updated periodically as new lists are made available from FNS. If a facility is listed, then the county can be sure that an individual residing at the facility meets an exception to the Residents of Institutions rule and may be CalFresh eligible. If a facility is not listed, the county can confirm that the facility is otherwise operating under the Public Health Act, the Social Security Act, or whatever else is required depending on the type of institution. For example, confirm that a homeless shelter is indeed a homeless shelter. To do so, the county may request verification from the facility itself or can work with CDSS to determine if the appropriate state agency has licensed the facility. So there are a couple different options for verifying. One place to start is definitely the FNS authorized retailer list. Before we move on to providing eligibility guidance by type of institution, I'd like to provide one more definition for a term that we will be using throughout the remainder of the presentation: authorized representative, or AR. An authorized representative is an adult, non-household member who is authorized to act on behalf of a household to complete the application process, to obtain CalFresh benefits, and/or to use CalFresh benefits. This is an individual who is not part of the CalFresh household. This person may be, for example, a relative or a friend who is familiar with the household circumstances. As well, in certain situations, an employee of an institution may be designated to act as an AR for an individual residing at that institution. That's why I mention it here. We're going to talk more about the role of ARs throughout the remainder of the presentation. For more info on designating an AR, you want to tune into the next webinar, which we already mentioned, but I'll plug again, the CalFresh rules for authorized representatives. That's on Tuesday, March 5th. We'll get into a lot more detail there about the AR role and how they are designated. I'm now going to provide eligibility guidance by type of institution. If an individual is not subject to the Residents of Institutions rule and may be eligible to CalFresh, there are specific eligibility rules that need to be kept in mind. Let's start with eligibility guidance related to DAA center residents. Individuals who are narcotic addicts or alcoholics and who regularly participate in a residential treatment and rehabilitation program may voluntarily apply for CalFresh. Prior to approving any DAA center resident, the county must confirm that the DAA center is authorized by FNS as a retailer or that the program is operating under the Public Health Act, Title 19. Remember, counties can use the FNS list posted to CDSS's website to confirm whether the DAA Center is an authorized FNS retailer. Otherwise, additional verification from the facility or appropriate state agency may be required. Confirming that an individual is a resident of a DAA Center is step one. There are a couple of other things that must be kept in mind. DAA Center residents applying for CalFresh must apply through an authorized representative, or AR, employed and designated by the DAA Center. This rule is specific to DAA Centers, so please keep in mind they must apply through an AR designated and employed by the DAA Center. For receiving and using benefits, the county may require DAA Center residents to designate the center as their AR for that purpose. This flexibility is dependent on how the DAA Center provides meals to residents and should be determined on a case-by-case basis. For example, a DAA Center may shop on behalf of residents to prepare group meals. In this case, designating the DAA Center to receive and use benefits makes sense. Whereas, if the DAA Center accepts CalFresh benefits for each meal via a point-of-sale device, then the DAA Center may act on their own behalf to use their CalFresh benefits at that point-of-sale device. Note that when a DAA Center is designated employee is acting as an AR, regardless of the function, the DAA Center is responsible for notifying the county of any changes in the household circumstances that are required to be reported. DAA Center residents must apply for CalFresh as a separate household from others with whom they reside. Further, DAA Center residents must apply as a household of one, unless their children are residing with them. If their children are residing with them at the treatment center, they can apply as a multi-person household. Note that the one-person household rule applies to spouses as well. Even if two spouses are residing together at a DAA Center, they must apply separately. When acting as an authorized representative for the purpose of using CalFresh benefits, a DAA Center may redeem benefits by using a resident's individual EBT card or using a DAA Center EBT card that is an aggregate of individual household benefits. A DAA Center can also be authorized as a retailer with an EBT point-of-sale device. With a point-of-sale device, CalFresh benefits can be deposited directly into the facility's financial institution accounts. The DAA Center may also accept CalFresh benefits from non-residents of the program at the program's communal dining facility, if applicable. So if a DAA Center has a combination of residential and non-residential clients attending their program, the point-of-sale device could be used for both the residential and non-residential clients to purchase meals while they are there. In addition to the authorized representative-related responsibilities, DAA Centers also have certain responsibilities at the point in time when an individual leaves the center. When a household leaves the center, the DAA Center must inform the county that the individual has left the center. If possible, provide the household information about reporting required changes to the county because they are now acting on their own behalf instead of through the authorized representative designated by the center. Make sure that the authorized representative designation by the DAA Center is no longer applicable, so the DAA Center is no longer listed as the household's AR. Provide the household with its EBT card, if applicable. So if they were holding the card for the person, provide it back to them. And depending on the time of the month the household leaves the DAA Center, return any prorated benefits. And again, this will depend on individual household circumstances. We'll talk later about a forthcoming all-county letter on this topic, but that letter will dive into a lot more detail about what is required once a resident leaves, particularly related to the proration of benefits. Now I'm going to provide eligibility guidance related to individuals who are residents of a group living arrangement, or GLA. Individuals who are blind or disabled and residing at a GLA may apply for CalFresh. Prior to approving any GLA resident for CalFresh, the CWD or the county must confirm that the GLA is either authorized by FNS as a retailer or is operating under the Social Security Act. Similar to DAA centers, GLAs also appear on the FNS list of authorized retailers posted on our website. If a county cannot find a GLA on the FNS list, then they should verify that the GLA is operating under the Social Security Act or work with the appropriate state licensing agency, in this case, the California Department of Social Services. Unlike DAA center residents, GLA residents don't necessarily have to apply through an authorized representative designated by the GLA. GLA residents can either, 1, apply on their own, or 2, apply through the use of an authorized representative. The authorized representative can be employed and designated by the GLA, or be an authorized representative of the individual's choice. If a GLA designated employee is acting as an authorized representative, like a DAA center, they must fulfill all the authorized representative responsibilities, including letting the county know of any household changes required to be reported. I mentioned that GLA residents may apply for CalFresh on their own behalf. That said, some GLA residents may not be able to do so. A GLA is responsible for determining if a resident can apply on their own behalf or not. The GLA must determine if a resident is able to handle his or her own affairs. This is based on the resident's physical and mental ability. And again, this assessment will be made by the GLA. If a GLA resident applies on their own, the GLA may either act as the household authorized representative for purposes, let me start over here. If a GLA resident applies on their own, the GLA may either act as the household authorized representative for purposes of obtaining and using CalFresh benefits. So the distinction here, and this is what I was trying to make sure was clear, is that the GLA resident may apply on their own but still authorize or designate an authorized representative for purposes of obtaining and using the benefits, or they can apply on their own and use their own EBT card. Sorry for the confusion there. When acting as a resident's authorized representative for purposes of using CalFresh benefits, the GLA may redeem benefits by using a resident's individual EBT card or using a GLA card that is an aggregate of individual household benefits. As well, a GLA can be authorized as a retailer with an EBT point-of-sale device. The GLA may also accept CalFresh benefits for non-residents of the program at the program's communal dining facility. So this is very similar to how benefits may be redeemed at a DAA center. One distinction, that the GLA may also purchase and prepare food to be consumed by eligible residents on a group basis, as long as at least one of a couple of things are true. Residents normally obtain their meals at a central location where residents all eat together, or meals are prepared at a central location for delivery to the individual residents. As long as one of those two things are true, then the GLA may purchase food to be consumed on a group basis. Like DAA centers, GLAs have certain responsibilities when residents leave the GLA. These differ slightly from the responsibilities of DAA centers, so we have presented this on its own slide. When a household leaves a GLA, the GLA must provide the household with its EBT card, if applicable, and depending on the time of the month, return any prorated benefits, again, if applicable. Return to the county EBT cards not provided to departing residents at the end of each month, particularly if any residents have passed away. and if possible, provide the household with information about reporting required changes to the county. Again, because the GLA is no longer acting as the authorized representative, they should provide the household with info about how they can report changes on their own. There are some roles and responsibilities that apply to both GLAs and DAA centers. We're going to go over those now. When acting as an authorized representative, a DAA center or GLA is not only responsible for being knowledgeable about household circumstances. The DAA center or GLA is also responsible for any misrepresentation or intentional program violation which it knowingly commits in the certification of an individual resident. The DAA center or a GLA is also liable for all losses or misuse of benefits and/or EBT cards held on behalf of individual residents, and for all overissuances which occur while the households are residents. When certifying DAA center and GLA residents, the county also has some additional responsibilities. If F&S disqualifies the facility as an authorized CalFresh retailer, this county must suspend the facility's authorized representative status. As well, the county should notify F&S if the county has reason to believe a facility is misusing CalFresh benefits and/or EBT cards. And here at the Department of Social Services, we can help facilitate that sharing of information with F&S. The next type of institution that is exempt from the Residents of Institutions rule are battered persons shelters. I provided a definition of a battered person shelter earlier, but just to review, these are public or private nonprofit shelters for battered persons. If the shelter also serves other individuals, a portion of the facility must be set aside on a long-term basis to serve only battered persons. The shelter must serve meals or provide food to restaurants, and the shelter provides food to residents. The shelter must be authorized by F&S or confirmed by the county to be a battered person shelter. Note that regulatory guidance on shelters for battered persons can be found in the section with guidance on meal service providers, which we're going to discuss in just a minute. Shelters for battered persons fall into the category of an institution that is exempt from the Residents of Institutions rule and falls into the category of meal service providers. Today, we are talking about them as an institution. Residents of battered person shelters may either apply for CalFresh on their own behalf or through an authorized representative. The authorized representative may be employed and designated by the shelter or may be an authorized representative of the individual's choice. If a shelter resident applies for CalFresh benefits on their own behalf, there are a couple of different ways the benefits can be used. They can be used by the eligible resident to purchase and prepare food for their own consumption, such as at a grocery store, or to purchase meals prepared and served by the shelter, either communally or individually. Battered person shelters can be equipped by F&S to have an EBT point-of-sale device. The next type of institutions are shelters for homeless persons. A shelter for homeless persons or homeless meal provider is a type of facility that provides meals to homeless persons. Homeless meal providers are public or private nonprofit establishments, such as a soup kitchen or temporary shelter, that feed homeless persons and are authorized by F&S as a retailer or are confirmed by the county as a homeless shelter/homeless meal provider. To be allowed to accept CalFresh benefits, meals served by the homeless meal provider or shelter must include food that is purchased by the homeless shelter or meal provider. The meals cannot consist wholly of donated foods. Shelters for homeless persons cannot act as a CalFresh recipient's authorized representative. Similar to shelters for battered persons, shelter for homeless persons fall both into the category of an institution that is exempt from the Residents of Institutions rule and a meal service provider. Hence, you see those two terms used interchangeably. Homeless meal providers may only request voluntary use of CalFresh benefits from homeless recipients to pay for meals. They also cannot ask CalFresh recipients to pay more than the average cost of the meal at the shelter. If a non-CalFresh client has the option to eat free or make a monetary donation, the CalFresh recipient must have the same option. We covered guidance related to specific types of institutions, and now we are going to discuss CalFresh meal service providers. Some meal service providers are residential facilities, and some are non-residential facilities. We've already discussed two types, shelters for battered persons and shelters for homeless persons, which fall both into the category of an institution and a meal service provider. Now we're going to discuss a couple of others, meal delivery services, communal dining facilities, and senior citizen centers and apartment buildings. This guidance on meal service providers is separate and apart from determining eligibility for persons who reside in an institution, but we're covering it today because many SSI recipients may receive meals from a meal service provider and should be considered eligible for CalFresh. So first, what exactly is a CalFresh meal service provider? A meal service provider, or MSP, is an F&S approved retail food store that is allowed to provide meals to CalFresh participants in exchange for CalFresh benefits. There are several types of meal service providers. We've already highlighted two, battered persons shelters and shelters for homeless persons or homeless meal providers. There are also meal delivery services such as Meals on Wheels, communal dining facilities, and senior citizen centers or apartment buildings. One quick note here, quick but important. A shelter for homeless persons may also provide meals to homeless persons not residing at the shelter. Homeless persons may use their benefits at homeless shelters under the same rules as homeless persons that are residing there. Primarily, the rule to keep in mind is all payment using CalFresh benefits must be on a voluntary basis if they're made at a homeless shelter. Okay, we've already defined a shelter for battered persons and a shelter for homeless persons. The next type of meal service provider is a meal delivery service. These are public or private nonprofits that prepare and deliver meals at concessional prices to elderly persons who are housebound and or disabled and their spouses. Meal delivery services must be authorized by F&S in order to accept CalFresh benefits. The payment for delivered meals must be voluntary. When a CalFresh recipient elects to pay for a delivered meal, the service can accept payment one meal at a time, or for more than one meal at a time can accept payments once a month. If non-CalFresh recipients have the option to eat for free or make a monetary donation, the same option must be available to CalFresh recipients. And the county must have a way to identify eligible recipients that can use their benefits at an authorized meal delivery service, even if it's just a notation in the case file. The next type of meal service provider are communal dining facilities. These facilities are public or nonprofit private establishments which prepare and serve meals to elderly persons or SSI recipients and their spouses. To accept CalFresh benefits, the provider must be authorized by F&S as a food retailer. Finally, senior citizen centers or apartment buildings may be meal service providers. These are private facilities occupied primarily by the elderly, disabled, and SSP recipients. Note, they do not provide residents a majority of meals. If they did, this would not be an exception to the residents of institutions in eligibility rule. So these are senior citizen centers or apartment buildings that are not recognized as institutions for which residing at would make you ineligible to benefits. To be allowed to accept CalFresh benefits, they must be authorized by F&S. So our key takeaways for today. Beginning on June 1st, 2019, A large influx of newly eligible SSI/SSP recipients, including residents of institutions, are expected to apply for CalFresh. CalFresh rules that apply to residents of institutions must be considered. Some residents of institutions will not be eligible for CalFresh, but there are exceptions. The exceptions we discussed today are an important component of making an accurate eligibility determination. Again, those exceptions are individuals who reside in federally subsidized housing for the elderly, individuals who are narcotic addicts or alcoholics and reside at a DAA center for the purpose of participating in an alcohol treatment or rehabilitation program, individuals who are disabled or blind and are residents of group living arrangements, individuals and their children who are temporarily residing in a shelter for battered persons, individuals who are residents of public or private nonprofit shelters for homeless persons, and residents of public institutions who apply for SSI prior to their release from the institution. You can always email us questions at calfreshssi@dss.ca.gov. And as I mentioned, an important resource is coming your way, an all-county letter providing more extensive guidance that was even covered today on the topic of eligibility for residents of institutions. As well, as a coincidence, because nothing in life is ever easy, the Food and Nutrition Service did release today final rule with some federal regulatory changes that do impact DAA centers and GLAs, so we'll make sure that those changes are incorporated to any forthcoming all-county information notices or all-county letters. So keep an eye out for that. Okay, let's go over some resources before we get to questions, though I will say if you have questions, now's the time to type them in. I think we've received quite a few, and so again, we'll not likely get to all of them live, but are keeping track, so please submit your questions. The next webinar is on March 5th from 10 to 11 a.m. We'll be discussing the CalFresh rules related to authorized representatives, which is a great follow-up to today's conversation. If you haven't already, you can register online on our CalFresh SSI webpage. The next all-stakeholder meeting is on March 13th from 1 to 2:30 p.m. The all-stakeholder meeting will be held in person here at CDSS and via webinar. Again, if you haven't registered already, you can do so online today. And finally, a list of some relevant policy guidance that's also available on our site and compiled here for your convenience. Okay, so now we're going to begin going over some questions. Just give me a chance to get organized here. Okay, so the first is just reconfirmation that the materials will be posted to our website over the next couple of days, the slides, a recording, and eventually a Q&A document as well. Okay, so our first question, and I'll try to do my best to answer it because I'm a little bit confused about what the person is trying to get at, but it's an example of when an SSI recipient who resides in an institution and is served the majority of meals would not meet the disability exception. And just to confirm, all SSI, SSP recipients are either elderly or disabled, or both elderly and disabled. And so this rule is not related to whether they are considered disabled for the purposes of CalFresh, but rather about whether they reside in an institution wherein residing in that institution, which is already providing them a majority of meals, makes them ineligible to CalFresh. So again, we talked about the eligibility rule really being driven by whether you receive the majority of your meals from that institution. If you are an SSI recipient who is getting the majority of your meals already from the institution as part of normal services, then you are ineligible for CalFresh unless you meet one of the exceptions, which we went over in detail. So It does not actually impact whether they are disabled or not. It impacts their eligibility for CalFresh benefits. Again, primarily driven by whether they receive the majority of their meals from that institution. Okay, this next question, and we'll put a resource related to this online as well. If a client is residing at a institution that provides the majority of meals, but they do not eat any of the meals provided due to strict dietary guidelines, would that person be eligible to CalFresh? This goes back to what it means for the meals to be provided as a normal part of service. And there is a memo on this topic from FNS. We'll make sure it gets posted online as well. But basically, if the meals are provided as normal service, whether the client eats them or not, then that person will be considered a resident of an institution and will be ineligible to CalFresh. So hopefully the facility is accommodating to dietary needs, because the question is not whether you eat the meals, but whether they are provided as a normal part of service. We'll make sure to post that memo as well, which talks about this issue as well as the fact that some meal plans are optional. So that can go up with our Q&A. Okay. This next question is about DAA centers needing to designate an employee to be the authorized representative, not the DAA center itself. Right, so a physical center cannot be an authorized representative. It needs to be an individual who can report for the household and knows enough about the household circumstances. So in this case, yes, the DAA center needs to designate an employee to fulfill the function of authorized representative on behalf of the center. The authorized retailer list will be on the website right after this presentation. It was brought to our attention and may not be up quite yet, but we'll make sure that that is there. Okay, this next question is about a faith-based recovery home and whether it would be considered a DAA center. So the definition of DAA center has nothing to do with whether the center is faith-based or non-faith-based, excuse me. So you can sort of put that to the side and instead use the definition for a DAA center that we provided, whether it's authorized by FNS as a retailer or operating under Title 19 of the Public Health Services Act. And you'll be able to go back in the slides later, but remember, to be operating under Title 19 of the Public Health Service Act, you either need to be receiving funding through that act, have not receiving it today, but eligible to receive it if it were available, or furthering the goals of Title 19, which primarily is related to the medical component for drug addiction and alcohol rehabilitation. So if you run into a faith-based recovery home, you need to go back to the definition of DAA center, find them on the FNS retailer list, or verify that they are indeed operating under Title 19 of the Public Health Services Act. You can come to us if you have questions, but again, the definition is not driven by whether it's faith-based or not. Okay, this next question is about whether it matters how many meals the client receives at a homeless shelter. No, because homeless shelters are an exception to the residence of institutions rule. So again, first you need to ask yourself, is the person a resident of an institution, to determine whether or not they may be CalFresh eligible. That definition is primarily driven by how many meals they receive, but there's also a list of exceptions. Homeless shelters are included on that list of exceptions, so the number of meals provided is irrelevant. The homeless shelter is on the list of exceptions. Does CDSS have a plan for making sure all of these types of institutions are aware that SSI recipients will be eligible for CalFresh? That's a great question, and we'll be incorporating it into our outreach and communication strategy. Right now, our first step is making sure that we are all on the same page about the eligibility rules. This webinar, the forthcoming ACL, is kind of a starting place for that, making sure we all know how to apply the rule, and then building that into our communications strategy as well. Okay, give me a minute here to go through our list again. Let's just see. Hang in there with us. Okay. When is the ACL expected to be released? The ACL is going out for stakeholder review this week. So depending on how long that takes, we hope to get it posted before implementation. Note, it is a really long ACL. It's about 15 pages. So if you're one of our partners involved in stakeholder review, that is coming your way. It's quite a hefty read, so keep an eye out. Okay. Just give us another minute. There are some basic questions related to the reversal of cash out. We'll make sure to follow up on those. Today, we want to dedicate our time to the residents of institution policy, so just give us a minute. Okay, we are getting some additional questions. We're going to have to follow up with folks because we're not super clear on the questions, but don't worry, everything is being logged. Okay, this is a question here about if a DAA center designates an employee, which they must, to act as the AR for the individual to apply. If an overissuance occurs while the person is a resident of an institution, will the individual be responsible or will the DAA center be responsible? We talked a little bit about this in the slides, but the DAA centers, when acting as authorized representatives, do have responsibility for overissuance as well as any type of misinterpretation or intentional program violation that occurs while the individual is a resident of their institution. So yes, there are responsibilities that come with acting as an AR while that individual is residing at the DAA center. Okay, we'll give folks just another minute, and if we haven't gotten to your question, we'll follow up with you for additional clarification and or to get you an answer. Okay, so I think we're just about ready to wrap up. Again, we've gotten some, okay. Here's one more, just again in regards to the DAA centers acting as authorized representatives. Should NOAAs be directed to the DAA center or the designated AR for the DAA center? The NOAA should go to the employee designated by the DAA center as the AR. I don't think it's harmful to notate the DAA center at which the designated employee is employed. So, you know, you can put, for example, Alexis Fernandez at DAA center XYZ so that you can keep track of that individual being authorized, the authorized representative for the resident at the DAA center. Just another question here. I did respond to this. The authorized representative is responsible for an OI that occurs while the individual is residing at the facility. That was covered on one of the past slides as well. So again, this is similar to when individuals act as authorized representatives, they have to be familiar with the household circumstances, and they have to complete reporting requirements for the household, and may be liable for any misinterpretation or potential program violation, or even misreport while the individual is a resident at the facility. Okay. So looking at the time and just not seeing any other pending questions, we are going to wrap up for today. Thank you for joining us. Again, if additional questions come up, please do reach out. We will do our best to address those, and we will follow up on the few that we need some clarification before responding to. So thank you all for joining us, and we'll see you, I believe, on March 5th for our next webinar on authorized representatives.